Hi, I'm Quinn.
Hi, I'm Scott.
Hi, I'm Adrian.
And we're the Law Boys.
Yeah, I'm trying to it's really good to start their videos. Like, hi for the next
Oi, boys!
Oh, Quinn, are you okay?
Yeah, but what were you doing leaving this lying around here? Anyone could have slipped on it.
Adrian, did you leave a bloody biscuit on the floor and not clean it up?
No. Oh. Sorry. I just remembered. This reminds me of a case. Strong v. Woolworths.
Oh yeah, that's the one where the lady was walking out the front of Big W and slipped on a chip, but it wasn't cleaned up.
Let's go check it out.
Let's go, boys.
Oh gosh, it's always nice to look at some plants after a busy day of shopping at Big W. Oh, that's a nice one. Yes.
Yep.
Oh, it's been a busy day shopping at Big W. Oh, isn't this nice? Herbal, I think. Much better than those nasty vaccines. Oh my, this one would look nice at home. Hold me back. What a handsome boy.
Alright, here we go again. Calling into session the case of Strong v. Woolworths. It says here, Mr. Strong, that you slipped on a chip.
I'm an old woman with a walking aid.
Madam, that's a stick. You do know that, right?
Well, we are on a low budget, okay?
And didn't you just clean it up? Or was that like a problem?
Well, actually, Your Honour, we'll always implement a very strict cleaning regime to ensure customer safety and satisfaction.
Okay. Gee. Alright, I think this is time for a but-for test. So, but for Woolworths not cleaning up the chip, Mrs. Strong wouldn't have slipped, she wouldn't have gotten her injuries, and I wouldn't have to be in today. Alright, so, Miss Strong, on a pain scale of 1 to 10, how bad is your injury?
20. It's quite severe.
Oh, okay, well, in that case, I guess we'll find in favor of the plaintiff and award her $500,000. I think that's a good number. Court adjourned.
Ha! Take that, Sonny. Oh, me back.
Therefore, it was found to be more likely than not that the chip would have been on the ground for longer than 15-20 minutes. And Woolworths were found to be in breach of their duty to provide a safe and clean space. And at the end of this, Strong was awarded damages of $580,000.
So, the main elements of causation then is factual causation, which is basically asking, did the defendant cause the injury? And scope of liability, which is the defendant liable for the injury caused? So, factual causation is a question of fact. Question 1, would the harm have occurred but for the negligence? If yes, then that's where we stop. If not, defendant's negligence caused the injury. Question 2, was the negligence a necessary condition for the harm? If yes, defendant's negligence is a cause.
So, let's look at scope of liability. We look at the extent of the defendant's liability in the situation. For example, is the harm too remote? It's not too remote if the harm is foreseeable as a possible consequence of the actions in the circumstance. And are there any intervening acts? So when we look at this, we look at whether the chain of causation progresses neatly from one event to the other without any intervention from the plaintiff's own actions or another third party. Hang on, take a chip.
Adrian, come on, man, you're dropping chips everywhere. Man, if I stepped over, I could have sued you.
well, looks like we didn't learn anything from Strong v. Woolworths.
But if you did learn something, hit that like button, give our channel a subscribe, or if you want a specific case for us to do, chuck us a comment.
Thanks for watching.
We've been the Law Boys.